Number 27, the people of the state of New York versus Kenneth Slade. Counsel?
Good afternoon. My name is John Palmer. I'm here on behalf of Kenneth Slade. I'd like to request 2 minutes for rebuttal.
You may, Mr. Palmer.
The people failed to file a certificate of translation to cure a hearsay defect that they knew about within 90 days of Mr. Slade's arraignment.
Counsel,
In fact,
Counsel, this is Judge Stein. I have a question for you. How do we reconcile your position that the certificate needs to be submitted with our, what I will call our four corners jurisprudence about determining the legal sufficiency from the four corners of the document itself? And most recently, I think we referred to that in our Hardy case. So how do you reconcile your position with that?
right. So the defect here was latent. Latent in that it does not make the instrument facially insufficient, but the defect is not without consequence, as the complaint here did contain hearsay, and the prosecution could not have stated ready on a complaint that contained hearsay, as they had to have had a information, piece or instrument free of hearsay, to take Mr. Slade to trial.
How is this hearsay?
This hearsay.
Go ahead.
It is hearsay because the complaint's factual allegations were hearsay in that they were not the complainants, but they were a secondhand write-up of the allegations. And as this court found in Edward B., even when a complainant signs an affidavit or a supporting deposition, that hearsay defect is not cured until the complainant knows what the instrument says and adopts the allegations.
Well,
couldn't
there be a lot of reasons why there might be a certificate of translation? Maybe it just would make it faster. Maybe somebody can read and understand English, but it takes them a while, and they're trying to, a lot of different reasons. So why would that necessarily indicate that the person who signed and verified the instrument didn't understand and that it wasn't their words?
Well, it shows that the prosecution at the time that the complaint was signed deemed translation a necessary part of the drafting process.
I'm a little confused, as Judge Fahey here. I'm a little confused on how it could be hearsay on the face of the deposition within the four corners of the document.
It is not hearsay within the four corners of the document, but we know from the prosecution's own filing that the factual allegations were, in fact, hearsay because they were not the complainants.
Wouldn't you normally, in that situation, I recall from my city court days, you'd file a written notice or request something within 45 days, as I recall?
Well, yeah,
if there was some insufficiency that you were seeking to correct if it was latent.
That's what a defense attorney as a defense would do if they knew about this defect within 45 days of arraignment.
I can see that. Aren't there some other options you might have, though? For instance, asked to file the motion in the interest of justice. It seems to me you'd have some other options to try and correct these latent defects.
Correct. And that, for example, if you filed a motion to dismiss for facial insufficiency, I guess depending on the trial court, they would then ask the prosecution to file a certificate of translation, as they have in other cases. But here, this defect was revealed. It was revealed, rather, that the prosecution always knew that knew of the defect from the beginning of the case, and revealed to the court in the defense when the prosecution filed certificate of translation well after those 45 days had passed for defense to make such a motion.
Counsel, the particular problem I have with that on the facts of your case is that if I understand it correctly, the complainant here, the deponent, is Mr. Slade's wife. So he ought to know his wife's fluency in English. He sees the deposition, and isn't there something incumbent on him, if he thinks this is a latent defect, to say, wait a minute, I want a certificate of translation? I mean, or put it differently, isn't it a fair inference that because he didn't do that, his wife actually understands English well enough and he knows that?
No, as defense counsel did not know of this defect or potential defect. And of course, even if Mr. Slade spoke to his wife in English, it is not a given that he had perfect knowledge of her language skills or that he would know to tell his attorney and know that her language ability was even relevant to pretrial litigation for him to tell his attorney that within 45 days to make such a motion. And even then, if that information he had could sustain a motion to dismiss on any ground. And here, counsel did not know that translation was a necessary step in the drafting process until the prosecution filed that certificate of translation demonstrating that the complaint contained hearsay, and then all of their prior statements of readiness on that accusatory instrument had been illusory.
Counsel, one of the areas I struggle with is there doesn't seem to be any statute or case law that the court may examine for latent defects that are not apparent on the face of the accusatory instrument. Is there anything you can point to that I should look at? Well,
Your Honor, requiring a certificate of translation gives effect to the CPL.
What I'm asking you is one of the courts in one of the cases, and I relied on 2101B of the CPLR. Outside of that, is there anything for you that you would point to, either statutory or case law, that would say that a court may examine an accusatory instrument for latent defects? In other words, those that are not on the facial, on the instrument itself.
Well, for example, intermediate appellate courts, such as the appellate term first department and the appellate division second department in cases like Edwards, Brooks, and Maslowski, have looked beyond the four corners of the instrument and found that the prosecution's filing of this certificate of translation was pretrial indicia that the translator's assistance was necessary and have required a certificate of translation to convert the complaint.
I see. Maslowski is what you're relying on.
Yes, as well as Edwards.
Thank you.
And as the people failed to convert the misdemeanor complaint into an information within 90 days, Mr. Slade's arraignment here, this court should reverse Mr. Slade's convictions and dismiss the charges.
Thank you, counsel. Counsel?
Thank you. Paul Anderson for the people. May it please the court. Your Honors, if we just look at the plain text of the statute in CPL Article 100, there is no requirement for, or as Judge Fahey was pointing out, any vehicle or mechanism for a court to disrupt the prosecution based on an allegation of a latent defect. And as we submitted with our briefs in Brooks, that's a feature, not a bug. And when the new CPL, after the Bartlett Commission, which removed misdemeanor preliminary hearings. So here, any issue with the certificate of translation or that a translator was used is an issue best left for trial. So the certificate here gives defense counsel notice that a translator was present when this was drafted, a translator was used, who can cross-examine the complainant about that translation. You can even call the translator themselves and maybe put that as part of your defense. But in no way does it affect the facial sufficiency of the instrument. And as this court has long held, we look at, as Your Honor pointed out, the four corners of the instrument, and we don't really need to look beyond that or delay prosecutions, which this has now tended to do.
But so let me ask you this, sorry, over here.
Yep.
If it turns out at trial that, let's say, the witness testifies, I saw this document, but I had no idea what it said because it was in English, and I just signed it because I was told to sign it, there's not a remedy for that, is that right?
No, Your Honor, but it would be the same thing if it was an English-speaking complaining witness. Like any witness, that would be an issue with. This isn't something that would be specific to non-native English speakers. Like any complaining witness could go on the stand and say, a prosecutor put this in my face, and I signed it, and didn't let me read it. So that still doesn't go one way or the other here. And in fact, so that there really would be no remedy to that other than, as this court noted in Edward B., don't do it, or if that would then go to the credibility of the complaining witness in trial. But
Well,
Well,
wouldn't you-
what is the wife in this case? What is the wife agreeing, what is her agreement to the words on the paper when she signs the complaint? What is that asserting?
that the facts in those allegations attributed to, and that complaint attributed to her, are based on her own personal knowledge.
Okay, so how can that be a valid document if she is unable to read the paper that she is signing?
Because it's still explained to her. I think we'd have the same issue if there was an illiterate witness or a blind complaining witness. Like, we wouldn't really need a certificate of reading out loud in that case. So it's something similar, and it's still a presumption looking at the four corners of the instrument that this was explained to her.
Yes, but if you're reading out loud, you're reading the actual words, and that's not what happens here. There's no reading of the actual words. There is someone who is taking the actual words and converting them into another language, correct?
Yes, Your Honor, or she assisted at least in this case. 'Cause
Assisting.
I believe because the prosecutor affirmed that she had many conversations in English, but I get what you're saying hypothetically if there's a translator present that a
Yes,
translator.
but there's nothing in the record to, or you can correct me, is there something in the record to clarify that she could read English or write English, even if poorly?
It's not in the record, Your Honor, yes.
Okay, all right. So again, how is the document valid when her statement is not valid? What you're saying is what she is representing by this signature cannot be valid.
It's because the statute says it's valid, and that's what we look at. And going forward, and if there's any issue, whether there's a discrepancy, that's a trial issue. So the issue here is, and it's very plain in that secondary source. I'm sorry, Judge, you're...
No, good, no,
There-
I'm listening, go ahead.
Then that secondary source, that when they reformed the CPL, it was to speed up trials so that we can get to that fact-finding situation, get out of that backlog and from the Bartlett Commission in 1968. And so these are all trial issues here. And if a court has any issue with this, there's still 100.30 sub 2, which lets the court be like, you know what, I'm not too confident here. Either there's something there.
Let me
Let's-
ask you the following. Why isn't the procedure the one I'm going to suggest to you? Which is you have a complainant who, let's assume for the moment, does not speak or write English, just for the moment. Okay. And so you want to get their statement in English, because the courts function in English. Fine. All right. So you have them, because it's their statement, either say it to someone who writes it in Spanish, the language will use Spanish, that they can read and that they speak, or they themselves write it out, maybe it's typed afterwards, in the language that they know. And that is their language, that is what they can agree to, they can read it, they can confirm it, and then a person takes that, maybe it's the same person who spoke with them, takes it, and does indeed, in a writing, translate it to English, and then writes on a separate document that they have translated it and explains their skill set. Why wouldn't that be the process? Because then you have a document in the language spoken and understood by the individual, the complainant, and so they are indeed asserting that that is what represents their articulation of the events, right? Either they said it to someone or they wrote it themselves. Why wouldn't that be the document? And then all you have to do is connect the dots to get that to English for the courts to be able to have their statement. And that way, defense counsel could take the materials and have it confirmed. Why couldn't that be the process?
Your Honor, that would be, I would agree with you that that would be admissible, or that would be a valid complaint if we went through all of those steps. But once again, the statute in Article CPL 100 doesn't require all of that in there. So just complying with the statute itself, having this witness swear under penalty of perjury, the underlying allegations based on their personal knowledge, that's sufficient under the statute.
So let me-
whether
What
it's-
I'm saying to you is I don't know how the document is valid when the person doesn't understand the document. Which is to me different from your response to Judge Wilson, which is anybody could just refuse to read it and sign it. Well, we all take a risk that that's what's gone on. Someone hasn't paid attention, that's in contracts, right? They don't pay attention, they sign something.
Yes, Your Honor, but once again,
Which is
it's,
different from I could not, if I wanted to, understand what's in front of me.
Your Honor, that would go beyond the four corners of the complaint. And once again, there has been complaining
But
witnesses
if
who
the
spoke other
complaint
languages.
is ab initio, something that is null and void, right? Because she is signing something that she cannot appreciate. I'm finding it very difficult to get past that.
Well, these were all considerations. Like, there were witnesses who didn't speak English back in 1968 or prior to 1968. These were all considerations that we presume the legislature factored in. And these policy arguments that Your Honor is proposing, they are very valid, but I don't think they're appropriate here when we're looking at the CPL itself and
Could
what
I
are the
ask you
requirements.
could I ask you a practical question? So in this case, you had actually contemporaneously produced a certificate of translation. Is that commonly what your office does?
What do you mean by, generate the document at the same time?
Well, I don't even know at the same time, but here there was one that was produced roughly contemporaneously with the accusatory instrument. It just wasn't delivered to anybody, but it had been created, right?
Yes, Your Honor.
Is that usually what you do when you have a language-speaking witness?
Yes, in the complaint room, you'll have the prosecutor assisted with a translator, and we would memorialize that. I think just because there's really, the certificate of translation is a rule that, or is a document kind of crafted through criminal courts. As from, I think, 1996, Kings County Criminal Court in People v. Dino Allen was the first case to introduce this concept and rejected the idea. I think Legal Aid Society of Brooklyn proposed it, and then a year and a half later, another criminal court from Kings County decided, actually, let's have these file these documents. So I think our office and many offices do that, just belt and suspenders it, let defense counsel know that there's a translator here.
Is it burdensome?
Excuse me?
Is it burdensome?
To fill out the document, no, but in terms of, if, I guess more, this would be appropriate for Brooks, but we don't know what the court would want in the document other than what we have here, which
Right.
here's the person that used it, this is the language that it was translated from.
I mean, in some ways, that's the real practical problem here, right, is that you've got all kinds of different intermediate courts saying, you apply the CPLR, no, you don't, it's not clear at all what you're supposed to put in that little piece of paper.
Which is why I think this is more of a discovery issue, or an issue for trial, just to let everyone know that this person used a translator, here's the translator's name, if you want to voir dire on that, or cross-examine the
Well,
complaining.
don't you at a minimum need an assertion from the person who claims they translated that they actually do have the skill set to do that? I mean, this is a skill. Not everyone can do this. You agree with that?
Yes, Your Honor.
Right. So you need an appropriate skill set to be able to do this.
Yes, but we don't really know, there's no statutory guidance of what's the floor necessary. And so
Yeah, and
once again,
isn't that the
that'd be-
problem? Then we can't necessarily have confidence in the translation or in an interpretation.
But I
You
think-
don't have someone who can set forth that they are skilled in the ability to do this task.
But there's no requirement. These are, once again, policy arguments, I think, for the legislature to enact that here's what's required. For example, when we're in grand jury, when we're presenting cases in grand jury, we have to use and there's a witness who doesn't speak English. We use an interpreter who has their qualifications filed in the court. I don't have the CPL provision, but yes, but that's because we look at the statute, and the statute tells us what we're required to do.
But
And
what do
so-
you think is the policy that drives that? I mean, you'd have to do it in court too. So what do you think drives that? What's the point of that?
Is to ensure that when this witness is here testifying to that, the ultimate question of guilt or innocence, or I guess in the case of the grand jury, probable cause, that is an accurate translation for
Well,
the
why
court to
should this be
decide.
any less, since this is what puts the defendant on the path to face the
Because
government and a prosecution?
Because the legislature intended that. There's no misdemeanor preliminary hearings in New York anymore, which would have, presumably if we had misdemeanor preliminary hearings, we'd go through the same qualified translators filed on the court, but here, the legislature made a purposeful choice to here's what's required to go forward.
So
Here's
does
the
that
source of
treat
the
complainants
allegation.
and defendants who don't speak English, can't read English, can't write English differently?
Did you
then-
say defendants, Your Honor? I'm
De-
sorry.
Well, defendants and complainants, or whoever might otherwise be providing a supporting statement, right? Does it treat them differently under the law in a way that's not really justifiable if the law has found other ways to accommodate them, to get a statement that's accurate from them?
I guess I'm not too sure of your question. Does the legislative scheme as now treat them differently? No, or as your
This
Honor
process,
proposing?
you're saying the law doesn't require it here, but it requires it there. So I'm asking you about that different treatment.
The different treatment versus here and there is felony, either through felony cases through grand jury or the actual ultimate question of guilt or innocence at trial. But in terms of pretrial misdemeanors, this is what the legislature has deemed necessary to proceed. And at
Thank
every
you,
stage,
counsel.
we've complied with that. And
Thank
that's
you,
the affirm-
counsel.
thank you.
Mr. Palmer?
I would just like to elaborate on two issues that we touched upon in the respondent's argument. Is that the respondent is saying that because the instrument, they're essentially arguing for strict compliance to the CPL, and if it looks facially sufficient for in the CPL, that's kind of the end of the question. But here, if the prosecution acknowledged, at arraignment on this same instrument that it contained hearsay, the defense would have no recourse as long as the defect was not apparent on the face of the instrument. There is no grand jury in misdemeanor prosecutions, as the respondent pointed out, and there would simply be no assurance that this is a direct, complete, and adequately investigated case. And further, the prosecution has stated that they do already use these documents,
Counsel,
but they say it is issue for discovery.
Counsel, can I ask you a question? What's the purpose of the hearsay requirement or the non-hearsay requirement? Isn't it to give notice of the, sufficient to enable the defendant to prepare a defense and to preclude double jeopardy? And isn't that met under the circumstances here, or aren't those purposes met under the circumstances here?
So the purpose of the instrument generally and the reasonable cause requirement as well would be to provide notice and for the alleged actions, but the non-hearsay allegation requirement is so that we know that there is a sound, supportable basis for the prosecution.
But if the legislature has decided that if there's an issue there, it can be addressed at trial, how does that prejudice the defendant in any way?
Well, if the issue was facial sufficiency, if counsel had moved for facial sufficiency, the complaint be found facially sufficient. But here the issue is readiness, and that the people knowingly proceeded on an instrument that they knew contained hearsay and could not bring Mr. Slade to trial on for over 2.5 years before they cured that defect.
Can I ask, Judge, just one other question?
Yes, Judge Slade.
One of the things that strikes me here is that the risk for latent defects that could be in the accusatory instrument, would you say that those risks of latent defects are different for English speakers or non-English speakers? Is there a distinction to be drawn between the risks for those two groups? In other words, the things that aren't on the accusatory instrument, that you've got the translation, and if the translation meets the statute, it's facially sufficient. So the question is there, as far as facial sufficiency, is there any distinction that we can look at between non-English speaking defendants or accused and English speaking accused, as far as facial sufficiency?
As far as the accused, no.
I see.
There would be no difference.
No distinction. The distinction really lies in what you can't see, right? The latent defect.
Well, the distinction lies in what the complainant can see and understand and then adopt as
I
their
understand
own
that. And that-
allegation.
But you're
To
not
ensure that you're
saying
saying
that defect in and of itself is a latent defect. You can't see it on the face of the instrument. You know it because of the circumstances of the case, but it's not apparent on the face of the instrument.
No, it is not apparent on the face of the instrument.
What I was trying to get at is there some distinction that we would look at that would be, that would go to something more fundamental, like English-speaking defendants would be treated differently as far as latent defects from non-English speaking defendants? That's why I asked the question.
Well, counsel, I think part of that question is it the only kind of defect that a non-English speaking defendant would be subject to?
I'm not sure I understand the question, sorry.
Well, if the problem is let's just take this example. The complainant doesn't speak English, and it's not obvious from the face of the accusatory instrument and supporting documentation that the only person who's put in a position that's, the person who's put in a different position in that context is the person who's the non-English speaking defendant, right? Or the defendant for whom the complaining witness is non-English speaking.
Correct. And that requiring a certificate of translation provides some further assurances in those cases.
Chief Judge,
as it
may I ask a
allows.
question?
Yeah, Judge Garcia?
I'm sorry, up here. I have a question. To follow up on that, from what Judge Rivera is saying, it really seems to me you're not disadvantaging the defendant who may or may not speak English. What you may be disadvantaging is the complaining witness who doesn't speak English, who now may have a greater bar to being able to be a complainant because there may be this assumption without some extra process imposed that it's hearsay. So to me, it seems like the unequal treatment potential here would not be between a defendant who speaks or doesn't speak English, because everything will be translated for that defendant, but it would be between an ability of a complaining witness to file a complaint or swear out an affidavit. Wouldn't that be the problem here?
Well, no, in that it does not make cases where complainants are non-English speaking more difficult to prosecute.
Well, I'm gonna
It
presume that
provides
it's
a
hearsay.
benefit
I'm gonna
to
presume that's
those
a
people
hearsay
in that
statement.
they're able to know the allegations, able to know what allegations are being attributed to them. They're able to ensure and confirm the accuracy of the allegations that are attributed to them. And as was outlined earlier, this is not a terribly difficult process. And it is one that the prosecutor's offices are already at least trying to do when they can. And as to respond to the respondent's argument that it's a discovery issue, they are not filing these documents right before trial as part of discovery. They're filing them frequently, it seems like, from the cases that we know of. They're filing them when they're trying to convert the accusatory instrument.
Thank you, counsel.
Thank you.